In today's blog, I would like to speak about accidents on leased or rented premises. We know that for years, of course, a person on property has a right to expect the landlord or landowner to engage in reasonable care for the property. And over the years, Massachusetts did away with what's known as the status of the person on the property. We used to hear of an invitee, a licensee, or a trespasser. Invitees and licensees have been merged into one, those lawfully on the premises as compared to those not lawfully on the premises. But the Supreme Judicial Court, the highest court of Massachusetts, has also permitted, since the 1970s, somebody to make a claim for breach of warranty of habitability. But that somebody has always been, until the last few years, someone who has leased the property or somebody living at that property. And their claim could be for breach of warranty of habitability. And that, as a warranty claim, has certain significant differences from a negligence claim. Before I get to those differences, however, I want to speak about to whom the Supreme Judicial Court has broadened this warranty of habitability to. And now it's not only tenants or people in the family who are tenants, but it is the tenants' guests. And the Supreme Judicial Court said in a case a couple of years ago, Garfield v. Scott, that we ought to broaden it because we no longer care about the status of the plaintiff. And this is in keeping with our new approach, and that a person who is a guest has an expectation that the tenant's home is safe, and that is part of the landlord's contractual obligation, and the landlord has to deliver and maintain habitable premises that comply with the building and sanitary codes. The court went on to discuss how they've eliminated the legal significance attached to the status of people, and that logic compels our conclusion that a lawful visitor, that's in addition to one who lives there, may also recover for personal injuries caused by a breach of warranty of habitability. So why is it so significant that now a tenant's guest can make that same claim under what's known as a warranty count, in addition to a negligence count? And there are two major factors, I submit, as to why it is a very significant thing. Number one, if you recover under a warranty count, you are not subject to the allegation of comparative negligence. There is no comparative negligence claim to be made by a defendant if the plaintiff recovers on a warranty count. And therefore, the plaintiff's damages will not be reduced by comparative negligence, or even in the case where a plaintiff is deemed 51% or more negligent, it will not be eliminated. So that is a very helpful thing for a plaintiff suing under a warranty count. The second factor that I enjoy on behalf of my clients in a warranty claim is the right to bring a 93A action. 93A is a term some of you may have heard. It's under the Massachusetts Consumer Protection Act, and it basically says that unfair acts in trade or business are hereby deemed unlawful. And if you do make out a claim under 93A, which you can with a breach of warranty, if you make that claim out, you are entitled to attorney's fees and possibly even multiple damages. The judge would make that decision after a trial. And that fact of attorney's fees and multiple damages, as I say, comes about because there is a warranty claim, and the Attorney General has issued years ago a regulation that says any breach of warranty is a 93A violation. The bottom line is there are two factors that you should expect your lawyer to benefit from if he or she is asserting a breach of warranty claim, now available to the tenant's guests. The first is no deduction for comparative negligence and the rights to enjoy the full recovery under the Mass Consumer Protection Act 93A. Thank you very much.